All right, let's go ahead and get started. My name is Lisa Rodriguez. I'm the Director of Retail National Accounts here at Newview Trust Company. And today's webinar is going to be on playing defense. So how to protect your assets from creditors and predators. Very interesting topic. Do want to start off by saying that we are not fiduciary. So we are not going to give you any investment advice or tell you where to invest. We always tell our clients to do their due diligence, check with their attorneys, their CPAs and tax professionals on whether or not something is a good investment for them. So this webinar today is strictly for educational purposes. And just to go over who we are, Newview is a full service custodian. We are a trust company. We're fully regulated. We have two offices. One is in South Dakota and one is also here in Longwood, Florida. That's where I am. We've been in business for 17 years. We have about 10,000 clients and currently custody 1.5 billion in client assets. We like to pride ourselves on being simple to do business with, making ourselves available and being responsive for our clients. Our four core values are passion, integrity, serving others, and accountability. And that is what we live by on a daily basis. Today's guest is Charles Castellon, and he represents investors and small business owners and their families as a long-term trusted advisor for their business and personal legal needs. He focuses his practice on counseling and representing individuals and business clients in the areas of commercial and residential real estate transactions, litigation, wills, trusts, and estates, and business matters, including business succession planning, transactions, and litigation. He began his legal career as a trial attorney in New York City back in 1992. In 2003, he made a life and career change by returning to Florida, where he had lived previously and always maintained strong roots while attending high school and college. Charles is active in community, civic, and professional associations. He presents and serves as a panelist on legal issues for organizations and associations throughout Florida, as well as actively publishing articles, blog posts, and media commentary on his areas of experience. We ask today that you use the Q&A function for any questions. So if you do have any questions, go ahead and put them in the Q&A function of the Zoom, and Charles will address those at the end of his presentation. So without further ado, here is Charles Castellon.
Hi, thank you, Lisa. Thank you for the introduction. And what Lisa did mention is that I am also a Newview client, been so for over 10 years. So it's a real thrill to be able to present to fellow Newview members and prospective members. What Glenn has built is a great team providing a great service. So let's get into the program. Okay, so you know that this presentation is about playing defense, asset protection, taking care of what you've already got. So why should you care about this? It doesn't have the glitz or the sex appeal, the sizzle of these wealth building programs that all the gurus and the coaches and educators are putting on, but it's important. And it's important because bad things happen. And you need to be ready for them, and you need to prepare ahead of time to have a game plan in place to mitigate the damage and prevent bad things from hurting you and your family. Okay. All the reading I've done, research, watching TED Talks, listening to various successful people over the years, I've come to believe that there's such a thing as universal success principles, because I keep running into the same themes that keep getting repeated from various sources. They get packaged in different ways and get expressed in different ways, but there are some really important recurring themes. And my favorite expression of a success principle is found in Stephen Covey's famous book, The 7 Habits of Highly Effective People. And I bet many, if not all of you, have read that book. And what Covey did, which is very effective and very accurate, was express how we spend our time, how we devote our resources, and what we focus our attention upon in a quadrant involving important and not important, urgent and not urgent. And the key to success in life, as well as business and investing, according to Covey, is found in quadrant 2, is the important and not urgent. And I do agree with Covey that people who've achieved the greatest success in all aspects of their lives do a good job of spending a lot of time and honoring quadrant 2. Unfortunately, you have the other quadrants, and the enemy of quadrant 2 is quadrant 3. Is the important, the not important, and urgent. It's the emails, the text messages, the Facebook alerts, the phone calls for unimportant matters that grab our attention and drain our energy and our focus and take us away from quadrant 2. And I bet right now many of you are glancing with one eye over at your phones or your other monitor for emails or texts or Facebook alert, like the Pavlov dogs that we've all become in this high-tech world that we live in which distractions and those shiny objects and squirrels running by are always grabbing our attention, and they keep us away from quadrant 2. And that's a challenge. But what we're going to talk about today in this program is squarely a quadrant 2 activity to help you achieve great success through planning and preemptive action. The beauty or the brilliance of quadrant 2 is that the more time you spend there, the smaller quadrant 1 becomes, which is the urgent and the important. Because with preventive care, you reduce the possibility of events that fall into quadrant 1 ever happening. Protecting your wealth is very much like protecting your health. And quadrant 2 activity involves preventive care. If you take care of yourself, if you eat well, you get exercise, you live in moderation, I like to say everything in moderation, including moderation, you're going to reduce the chance of a quadrant 1 event like a heart attack happening. And the same thing goes to holds true for your business and your investing. So playing defense is textbook quadrant 2 activity. It's about avoiding future pain. But the problem with preventing or avoiding future pain is that it's not happening. It may never happen. This is hypothetical potential pain that you might suffer, as opposed to quadrant 1 type of real pain, which inspires people to take action immediately. You go to the doctor, you get medication, you take care of it, but it's hard to get motivated to take care of future pain that you may or may never suffer. And it's never urgent until it is. And then quite often it's too late. So this is the kind of behavior that's subject to procrastination. What I'm talking about, asset protection planning, an extension of that is estate planning, which is about taking care of your family in the event of death or disability. And just about everybody who ultimately takes action thought about it a lot, procrastinated a lot because they were too busy and they couldn't get around to it. And then it's trigger moments that finally inspire action for people to stop thinking and actually execute on plans like this. And you hope that trigger moment isn't you. Just this week, I've had the misfortune of seeing 2 friends pass away actually on the same day on Monday. And it's the kind of thing that you never expected to happen to you. And just like when it comes to death or disability, financial catastrophe, or all the bad things that could happen, you just don't see it coming. And the preventive care is the key to make sure that you're ready in the event that it does happen. Another inspiration for this program is a book called The Millionaire Next Door, which I enjoyed greatly as a primer, a guide to building wealth based on the study of many millionaires and their habits and how they got there and what they and what practices they engaged in to get to where they achieve great financial success. And The Millionaire Next Door, the authors talk about the importance of making money, of course, which is achieving wealth, but they also talk about playing defense, which is protecting wealth. And what this is about is habits and lifestyle. And there's a cause and effect element to it. We've all heard of Warren Buffett. Does Buffett live in a Manhattan penthouse or a Malibu beach house? No, he lives in Omaha, in the same house he's lived in for past 50, 60 years. And you see people like Buffett and wealthy individuals like billionaires, and you wonder, well, why are they so frugal? Well, the cause and effect analysis should be maybe that they became billionaires because they've been frugal, because they protected every dollar and they played good defense. So that's what this program is about. Okay. So I want to go back to 2008. I know there's a lot of real estate investors in this audience, I would expect. NewView is a great place to invest in real estate through your self-directed qualified plan. And back in 2008, I started my firm called CPC Law, which was after the breakup of a prior partnership I had. And I'm always reminded of casinos back at that time because I like to go to casinos every now and then, or certainly before COVID. And every so often I'd play the craps table. And there's two ways to bet when you walk up to a craps table. You can either play the pass line and put your chips there, meaning that you're betting with the shooter, which is the more popular way to bet, that if the person throwing the dice wins, you win. Or you can bet the don't pass line, which is betting against the shooter and betting with the house, with the casino. So if they lose, you win. And it's not as fun, but the odds are pretty much the same. So at that time, I remember what happened in 2008 is when we had the market crash and the Great Recession, and I put all my chips on the don't pass line. I started a practice based on representing homeowners and investors in foreclosure and distress with their mortgages. I was helping them defend the foreclosures in court, work out loan modifications with their lenders, negotiate short sales, and contain the damage and help them get past this financial catastrophe and move on. And I enjoyed great success. Made a lot of money building that practice because it was easy. It was a historic financial crisis like we've never seen. And there were so many foreclosures, never had so much work. Well, later on, my business suffered. And I was slow to respond to the changing economic conditions and made a lot of mistakes. And I got into trouble. And just like so many business owners, came to realize how fast fortunes can change. And it was the very principles that I'm going to talk about in this presentation that helped me contain that damage and move on and mitigate the harm so I could rebuild. My experience through the foreclosure crisis did plant the seeds for this playing defense program because I had hundreds of clients who lost most or all of their wealth in foreclosure. And there may be some clients actually tuned in right now because so many of them came from that investor community that greatly overlaps the NewView community, especially with CFRI, the Investor Association. And it really reinforced some lessons I had learned years before, because back on September 11th, I was working in New York on Broadway, about 2 blocks from the World Trade Center, and I was there. And I saw the towers go down, and that was certainly a momentous, life-changing moment and a catalyst. And it really reinforced certain life lessons. And the lessons that I took away from September 11th is that no one is immune from a major catastrophe like a financial or health event that can make everything we've worked so hard to build come tumbling down. And life and wealth are precarious. It's never as stable and secure as we like to believe. And I've seen so many cautionary tales. I've had so many meetings, consultations, and interactions with clients and friends who suffered greatly and their fortunes turned very quickly. People who were millionaires up until 2018 and then it came tumbling down. But the inspirational stories are the people who've rebuilt, who've moved on to fight another day. So the foundation and the philosophy for playing defense has been developed over many years of my personal and business and legal experience. And the program is about building a fortress to protect you, your family, and your business using the available legal and financial tools. And I want to stress a holistic approach. We hear a lot about the work and life balance, and I think to a large extent it's misunderstood and something of a myth in achieving that balance between life and work, because work is just part of life, and we need to have an integration in our lives that takes into account our needs and demands of our family, our business, and our investments, and make them complement each other. And that is part of this program as well, is playing defense and taking care of this preventive action to make sure bad things don't happen and preempt bad things from happening. That should all be integrated into a holistic approach. So when you're protecting your business and your investments, you're also protecting your family. I want to talk about what playing defense is not, because many hear about asset protection and there's some stereotypes out there and some impressions that people have, and I want to dispel that. What I'm talking about today, it's not about tax evasion or avoidance. It's not about hiding assets. It's not about taking illegal, unethical, or immoral actions or activities. And I want to emphasize that our highest moral duty should be to ourselves, to our family, our stakeholders, whether they are our employees, partners, associates, investors. That's your highest moral duty. And if bad things happen and you get those creditors and predators coming after you and trying to take what you have, there's certainly no need to engage in any kind of illegal, unethical, or immoral activities to protect yourself, because if you do proper planning and you use those available legal and financial tools, you will greatly contain the damage. And it's also not about becoming bulletproof, which is something that a lot of programs, workshops out there are trying to sell. I'm here to tell you that there's no such thing as being 100% bulletproof. It is about just making yourself as resistant to harm and mitigating the damage that could come as best as possible using those available planning tools. But nobody is going to achieve that ultimate state of being untouchable, bulletproof, where you can do whatever you want and not suffer the consequences. And that's not what this is about. What playing defense is about is lifestyle and habits. It's not a diet. Going back to that comparison between wealth and health, why do so many diets fail? Is because it's considered a temporary lifestyle change where you adopt some new habits for a while, like you cut out carbs and you lose weight, and then you get burned out on it and you go back to your old ways and it comes back. So it's been said by many, going back to the ancient Greeks, that excellence is about habits. It's the small stuff that we do every day, the compound effect of the mundane, simple, everyday actions that lead to habits, and that leads to ultimate success. And if you have no assets or few assets, it doesn't matter. Now, I expect that in an audience like this of New View members or prospective clients, you're not going to have people without any assets, because you're here today. It's because you understand the importance of that and the importance of investing, and you're part of the 5%ers that Glenn Mather talks about. 5% of a qualified plan IRA owners across the country are self-directed. But even if you don't have much, this is still an important program because timing is crucial. And we're going to talk about, as we go further into this program, why timing is so important when you do things, as opposed to taking action at all, is you can't wait until you get into financial trouble, because at that point it's going to be too late. So if you set up your habits, your lifestyle, your plan, even when you don't have much and you're of modest means, if you ever get into trouble in the future, when you do have a lot of assets, it's going to be much easier to successfully defend yourself, your family, and your business. Okay. What playing defense is about is anticipating and preparing for, being ready for all the what ifs in life. It's about expecting the unexpected, about engaging in damage control. It's about getting negotiating leverage. When bad things start to happen, you have leverage because you're in a shielded, protected position, and you can get out of it with greatly mitigating the harm. It's about shielding your assets. It's about building your legacy for your family and protecting your family through estate planning, because estate planning is an extension of asset protection in general, because estate planning is all about protecting your family in the event of your death or disability. What it's about is titling, structuring, and distributing assets in the most effective way to shield them from attack from creditors and the predators, judgment holders, people who might sue you for a car accident or a business dispute. It's about discouraging and preventing attacks and getting that leverage to settle, because you're not going to be bulletproof. You're going to want to settle and resolve your disputes with as little harm as possible. Here's a key concept, and this is what I was talking about a moment ago, about why it's so essential to be proactive and not reactive. And you need to plan and take action when you don't have a care in the world. And the reason for that is a legal concept known as fraudulent conveyance. Simply put, fraudulent conveyance is a challenge to your actions if you sell, divest yourself, transfer title, get out of assets, if it's determined that it's for the purpose of avoiding, hindering, or delaying creditor claims. So fraudulent conveyance, when you get down to it in the legal world, is a challenge of something a debtor, someone suffering an attack, a judgment, where others want to take what you have. If you get rid of them and it's your assets, or divest yourself, or hide them, or change title in any way, and the court determines that your intent behind those actions was to avoid, hinder, or delay creditors, that constitutes fraudulent conveyance, and that allows the person coming after you, like the creditor or the judgment holder, to overturn what you did. So what's crucial is to be proactive and not reactive, because timing and intent are crucial. The circumstances surrounding the transfer of your asset to get to the underlying intent of the debtor is what's the key in a fraudulent conveyance challenge. So there's a spectrum of time, right? You got one end of the spectrum, everything is okay. You don't have a care in the world. To the other end of the spectrum, the hounds are on your trail. You've been sued. You had a judgment entered against you. Now you have to produce evidence. You have to testify at a deposition, or produce financial records, bank statements, and tell the person who's just won a judgment against you what you have, because now they have a legal right to find out and know what you have and come after it. So in the world of fraudulent conveyance, it's all about trying to get to the underlying intent based on the circumstances, because smoking gun evidence is very rare. You're not likely to find a confession, an email, a letter, recording stating that you are getting rid of a certain asset so that creditor can't get it. So the court is going to determine your intent, and they're going to look at all the surrounding circumstances. And when you do stuff in this context is absolutely about the most important thing. So in the legal world, there's a concept of the badges of fraud. It's what the court looks for to try to figure out what your intent was. Did you have an innocent intent to do a transaction, to sell or transfer an asset or get it out of the reach of creditors for a completely legitimate, sensible reason, like an estate planning strategy that is unrelated to keeping it away from the creditor. That's why the timing of the transfer is so important. When you make a transaction in relation to the debt. So think about it. What are all the circumstances in which you could run into financial or legal trouble that could trigger movement, transfer, sale of an asset? Well, on one end of the spectrum, you have somebody just making a demand, informal demand, sending you a letter saying that you owe them money. Then you work through that spectrum to the point of an attorney getting involved. Now they have a lawyer threatening to sue you. Then they file a lawsuit. Then you're defending a lawsuit, and then you lose the lawsuit. So envision that spectrum from you don't have a problem to somebody's making noise, making threats, you find yourself in court and you lose. And when the transfer happens in relation to that spectrum is going to go a long way in determining when the court analyzes this, what your intent was. And some examples of badges of fraud that are found in the statute involve whether the transfer was to an insider or a family participant, where, let's say, the classic quit claim deed your investment property to your brother-in-law for a song without taking market value, below fair market value, sweetheart deal, and getting yourself out of assets so somebody else can't get it under those suspicious, questionable circumstances. If that's what's going on, the court's not going to look favorably on that. And you're going to find yourself in a much worse position and trying to defend those transfers and argue that they're legitimate. So the more you do while you don't have a care in the world, when nobody's coming after you, excuse me. The more you do while nobody's coming after you, where you're not being threatened, while you're not being sued, when you're just doing sound financial and legal planning, those kinds of transactions are much, much more likely to be upheld if ever challenged, because how can anyone argue that what you did in terms of putting, for example, putting an asset into a trust, getting it out of your name or transferring it to an LLC or anything like that 2 years before you even got sued and had a legal dispute, that's going to be upheld. So the meat of the program that we're going to talk about today, I'm about to drill down into some specific strategies and tactics, is about exempt assets. And we're going to talk about what the kinds of assets or the way you can hold your wealth in manners that are exempt from creditor claims. The rest of the program, that's for another day, another presentation, involves creating silos, separating your assets, putting walls between them so you don't have the proverbial many eggs in one basket. It's about segregating your personal from your business assets. It's about using planning tools and strategies like LLCs, estate planning techniques, about business and succession planning, and insurance is a huge part of asset protection planning. But for today's purposes in this limited lunchtime webinar, we're just going to focus on one element of it, which is holding as much of your wealth as possible in exempt assets. Exempt means outside the reach of creditors. And as a general principle, you want to own as much as possible in exempt classes of assets that creditors can't touch. And these protections come from state or federal law or both. Okay. Who remembers MC Hammer? I heard this song on my Pandora feed, music feed this morning. Hope I'm not the only one who remembers MC Hammer, but his one-hit wonder was "You Can't Touch This." And that's what asset protection planning is when you're talking about exempt assets. It's not hiding the asset. You could come right out and tell anyone who wants to know or has a right to know what you own. But if it's owned in an exempt class or of asset, then you could say, here it is, but you can't touch this because legally you're prevented from going after that asset. So here are examples of exempt assets. If you're a NewView member client, you already know about this. Qualified plans, 401k, 403b for the nonprofit world, 529 college savings plans, IRAs, including self-directed, so commonly used for real estate investing. And traditional IRAs, Roth IRAs, pension plans, whether they be private or government, all of those are exempt assets that creditors can't touch. Qualified plans. There are restrictions on the ability to protect qualified plans. There's a cap of $1 million that can be protected, and only the principal balance is exempt. So if you reach the RMD phase of your life, the required minimum distributions, when you get to be 70 and a half on a traditional IRA, and you start taking distributions out, or you take distributions and you collect income from your qualified plans before for any reason you have to, those distributions and that income flow is not protected. A creditor can intercept that, but they can't touch the underlying balance. Okay. Point I think is worth making is that the strategies I'm discussing in this presentation today about playing defense and planning to protect what you have, they should be consistent with and make sense with what you're doing in the rest of your life. Remember, like, that holistic approach and that complementary management of your family, life, business, and investments. It should all make sense. So we know, not in this crowd of the 5%ers, but in general across the country, there's a retirement savings crisis. And as a nation, we are woefully unprepared for retirement and not planning, not setting aside enough money. So how are you doing with your retirement planning? Are you maximizing matching fund opportunities with your employers? Or are you putting in as much as you can within reason? Are you effectively managing your investments? You should be doing all this stuff anyway. So my point is that if you need to do this anyway, and we should all be preparing and planning for retirement effectively and intelligently, the asset protection benefits that come along with that is just gravy. It's an additional benefit that will help you tremendously while you're doing something that you should be doing anyway. Okay. Another class of exempt asset is marital properties. In the legal jargon, it's known as tenancy by the entireties, T by E, where it's only available to legally married couples. And instead of 50-50 ownership or any other percentage, each spouse owns an undivided 100% interest in the asset. And it's really available for virtually any asset. Most commonly, you see it in real estate. Most of us will have a marital home jointly owned by the spouses as husband and wife, or T by E. But it's not just for real estate. You can own bank accounts. You can own LLC membership interests. Virtually any asset can be owned and structured in that T by E classification. And though T by E assets are exempt from creditor claims, but the key is that the debtor or the person in trouble who needs protection, it can only be one of the spouses. In other words, there's a public policy behind this, is that if a married couple together own assets as T by E, and only one spouse is the one in trouble, the one in debt, the one being sued, the creditors of that one spouse can't go after the asset owned jointly by the spouses. And there's a public policy rationale behind that under Florida law. It's that if there's an innocent bystander spouse who co-owns an asset like an investment property, homestead property, bank account, they shouldn't be made to suffer for the spouse who got in trouble if they didn't have anything to do with that trouble. Where you lose this is when both spouses are equally liable. So it's an estate planning tool as well, because under T by E ownership, you have survivor rights. And one spouse passes, the other spouse gets full ownership of the asset, and you avoid probate, because probate wouldn't come into play until the last surviving spouse is gone. Sorry. So no protection if the spouses are equally liable. So an example of that, if they're co-borrowers on a promissory note, then T by E does not protect you because you're both equally liable for that debt. And one tip is avoid driving each other's cars. which is a very common thing that spouses do all the time. And the reason for that is that if you're at fault in a car accident and you're driving the car belonging to your spouse, or you're driving a car belonging to anybody else, there's two people who could get sued, is the driver who was at fault and the owner of the vehicle, as long as you were driving it with their permission and they knew or should have known you were driving it. So there's two different legal theories to be sued under that scenario. So if you're driving your spouse's car, you're going to lose that T by E protection if you're at fault in an accident, because you can get sued for being negligent and your spouse could get sued for being the owner of the car that the negligent driver was driving. So just a tip. Okay, Homestead. Florida Constitution prevents Homestead from attack by creditor claims, and there's 3 exceptions: is a mortgage lien, property taxes, and contractor liens for people who do work on your property. By statute, there's other exceptions like HOAs that could go after your property, but the Constitution protects Florida homestead, and there's no cap on the value of the homestead that's protected. Protection is so strong that it extends the surviving spouse and your heirs, where in probate, your heirs can inherit, your children, for example, can inherit your homestead property free from creditor claims. So the exemption survives the owner. Okay. Ways to use homestead to shield assets. You can use cash that would otherwise be subject to creditor claims and use that to buy or make a down payment on a homestead. You could spend that cash that somebody can go after to improve your property, increase the value, or pay down the mortgage and build up your equity. And here's the beauty of homestead protection in Florida. There's a case called Havoco. Florida Supreme Court decided some years ago that says that your intent doesn't matter. Remember fraudulent conveyance we talked about earlier in this presentation, where what your intent is in moving money around is crucial in determining whether those transactions can be upheld legally. That doesn't apply to homestead. Havoco case says that even if your intent is to take money that a creditor can get and pump it into your homestead in a way like legal money laundering, if you want to look at it that way, that is perfectly okay. So the takeaway from that is the timing is not as crucial when you're using homestead as a protective tool, because you're off that time spectrum. So you could have a judgment entered against you and have the creditors breathing down your neck, and you take that money and you put it into your homestead, that's protected. Okay. Sale of homestead, you could protect the proceeds from the sale to buy the next homestead. So if you have legal trouble, you have debts, and you sell your homestead, you could take those proceeds from the equity and use it to buy the next homestead, and that's protected against creditor claims. The key is that you have to have a good faith intent to reinvest in the next homestead. Don't commingle your funds. Segregate those funds from the sale of one homestead and use it to buy the next. And it must be made within a reasonable time. I've had clients do this. They sell a homestead, they may be in debt, they may be in bankruptcy, but as long as they take that money, set it aside and buy the next homestead within a reasonable time, and the courts have decided that 2 years is generally considered a reasonable time, that can be protected. Okay. Permanent life insurance and annuities. I just published an article yesterday on our blog. I encourage you to check out if you have an interest in learning more about these legal and financial planning tools. I call permanent life insurance and annuities the two-way player because it helps you with offense, making money, like the cash value that grows in your life insurance policy, and defense, because this money is exempt from creditors. The cash value in a permanent life insurance policy is exempt from creditors, as well as the principal and income from insurance policies. Insurance annuities. If you want to check out that article, go to our website, uslegalteam.com, and look at the blog. And it's a summary that goes into greater detail and drills down deeper of the benefits for both offense and defense for using these products. So that leads us to the conclusion of the presentation, and I'll throw it back to the NewView team for some Q&A.
Thank you so much, Charles. That was a lot of good information. I hope everyone was taking notes. So let's go ahead and see what questions we have. I have one from Chris. Charles, good afternoon. I was wondering if you do any legal work with defunct HOAs.
I'm sorry, legal work with what?
Defunct HOAs.
I never have, but be happy to discuss it. Not, depends what the issue is.
Okay. Got another one from Rick. Is the $1 million exemption for all IRA accounts in total, or each IRA account at different IRA custodians?
No, each account.
Okay. And let's see, we have comment. It's so important as a financial professional, talk to your clients about the need to accumulate and protect over a lifetime. Good morning, seeking an attorney who is well-versed in the laws, rules related to self-directed IRA investing. Any recommendations?
For self-directed IRA investing?
The rules and laws?
I mean, I've done some work in this area. I do know a friend of Newview, John Heyer, is an attorney that has done a lot of presentations and has represented many clients, specifically with self-directed IRA and tax issues. I'm sure you could get the information from Newview.
Got another question here. Does Florida protect distributions from IRAs?
Does Florida protect distributions from IRAs? Key point is that when you start taking distributions and tapping into the principal, that doesn't enjoy the level of protection that the principal of your account has. So that is a riskier situation because creditors can more easily grab that if you're pulling the money out.
Okay. To what extent is the Florida homestead position arguable for other states?
Florida has probably the most comprehensive and complete homestead protection probably of any state in the country. I've read charts of other states to see how they compare, especially when I've had clients who own or may reside in other states. And it's remarkable. Florida has no limit on the equity, the value of the property that can be protected. But I've seen other states that with a statute will read 10% of the equity or 20% of the equity is protected against creditors, or they might have caps on the value. So there's a lot of good reasons to live in Florida, but that level, the extensions of the homestead protection are probably greater than anywhere else.
All right, we have another question. What is the best way to protect debt-free investment assets like homes?
The best way to protect debt-free investment assets like homes, a couple of different ways. Very common user-friendly technique is to use an LLC. Limited liability companies are very easy to set up and manage. And as long as you don't commingle funds, you don't commit fraud, you don't do a series of bad things, you keep your personal assets separate from your business assets. Holding title of a non-homestead property in an LLC is a great tool. And land trusts, which many investors use and know about, are very effective too. This goes into something didn't really have time to talk about in this presentation because I presented a slice of the overall program, which is focusing on exempt assets, but I'll touch upon this briefly, is that you're creating silos, meaning you're separating assets from each other. So a tip I would offer is that if you're going to use an LLC to hold investment properties, make it a single purpose entity, meaning have one asset in that LLC. Or if you use a land trust, have one property in that trust, because it's going back to the cliche about the eggs in the basket. I had a prospective client on the phone once who was being threatened by Morgan & Morgan for a tenant injury in his property, which was owned by an LLC, but he had about 10 other properties owned by the same LLC. So that's an example of a legal attack that could go after all the other assets of the LLC. So if you're going to use tools and planning tactics like LLCs or land trusts, my general recommendation is to hold as little as possible in each entity.
Okay. We also have someone that says, can you sell your residence, use the surplus funds to pay toward the mortgage of an investment property, move into that one and make it your homestead?
Sure. Yeah, I mean, as long as you're actually living in the property and using it as your primary residence, you can't have more than one homestead. And this is different than registering it for tax exemption purposes. There's an overlap there. But the point to understand when you're thinking of homestead for purposes of asset protection, as opposed to the property tax exemption and discount and other factors, what's important is that you're actually living there and you're using it as your primary residence. And if that gets challenged, you have to show some facts. You have to present testimony evidence to show that you were actually using it as your homestead. But once you move in and establish that homestead, in most circumstances, it should be shielded.
Okay. It says, are properties titled in living trust also protected from creditors or creditors?
Most of the time, not if it's a revocable trust. Just a real brief primer on trusts, many different kinds of trusts, including land trusts, but they tend to fall into categories of revocable or irrevocable. If you title any asset, and this goes way beyond real property, you title any asset to a revocable trust just by having the trust own it. If it's revocable, meaning that you retain control of the trust as the grantor, the person who set up the trust, and you can move assets in and out, you could dissolve the trust, get it back, that's not likely or not going to give you asset protection benefits because you still retain control of the asset.
Okay. We have a couple of questions. What is homestead? Is it something we file with the county? And is your primary residence also known as homestead?
Yeah, homestead is the legal jargon for your primary residence where you live. But that just reinforces the point I made a moment ago about how there's different aspects of homestead. So one aspect is what we talked about today, is exemption from creditors, protection where somebody you owe a debt to, like a credit card, can't come after your home. There's other aspects to homestead, which is registering it with the county to qualify for the homestead exemption, where you get a reduced property tax bill because you're not taxed on the total amount of the value of the homestead. So those concepts get mixed up a lot, but I think a worthwhile point to understand is that you don't have to register as your homestead or register the property as your homestead with the county to get the asset protection benefits we discussed. There's probably not going to be a reason not to register because nobody wants to pay more taxes than they have to legally. But even if it's not registered, as long as you move into it, you're living in it, and you're conducting your life with that property as your primary residence, it should be protected against the creditors and predators, regardless of whether it's registered with the county as your homestead.
I think somebody had a follow-up. Can the name of an irrevocable trust be changed?
Yeah, I don't do much work with irrevocable trusts. Most of the trust work I do is revocable family trust for estate planning and a land trust. But I can't think of a reason why the name can't be changed. You have a lot more for irrevocable. You have other restrictions that I think would come into play.
Okay. Somebody said, what is that $1 million limit about that you were talking about?
$1 million in a qualified plan. So if you have your New View account that has $2 million in it, only the first $1 million is protected with that exemption that we talked about.
How much are we protected from creditors when we declare homestead? Does this amount differ from each state?
It differs greatly state to state, but fortunately, Florida has no cap on the value that's protected.
Okay, and then we have our family trust asset exposures grouped as in an LLC.
Can you repeat that?
Our family trust asset exposures grouped as in an LLC.
Family trust. Well, if I understand the question right, family trust, if it's a revocable family trust, is just not going to enjoy the same level of protection as other planning tools because it's revocable, and not likely to enjoy the same level of protection as an LLC, because the LLC is a separate entity from the individual, and an individual can incur debt, get into trouble, and what they own through their membership interest through an LLC is going to be largely shielded.
Okay. And then somebody commented John Hire equals realestatetexlaw.com. So that must be his website.
Yeah, he, you know, if you want to get a legal consultation, I don't know him personally. I've seen him present at NewView, and I followed him online on social media and his website, and he does seem to be a real expert in the issues that you deal with a self-directed IRA, mainly the tax issues, and tax is not my forte.
Okay, I think we're running on time here. So any other questions we'll address separately, or I'll get them over to Charles. And just to continue with the presentation, if you are interested in learning more about self-directed IRAs, you can text SDIRA and your first and last name to 484848. You'll receive the self-directed IRA guide from NewView. I do want to take this opportunity to thank Charles for your time today. Thank you for answering our questions. That's what we love about webinars, is we have access to answer questions that we may not get on a daily basis. So appreciate you coming over. If you want to contact NewView, the phone number is listed right on that slide, and that's my direct email and the website for newviewtrust.com. So again, have a wonderful day, and thank you so much.
Thank you.